from Mr. Natterson. The first of those relates to matters of confidentiality in relation to certain of the documents he has provided to the Commission. And the second of those relates to an application to cross-examine Ms. Tlatsana, who has given evidence. I'd like to deal with each of those in turn. Chair, you do have a copy of them before you. In relation to the application to maintain confidentiality of certain of the documents, Chair, that is the one before you, which is marked 12 of 2019. But you can... That's one related to confidentiality. Chair, as I understand the application, and Mr. Natterson is legally represented, his legal representatives will shortly place themselves on record, but I have discussed with him this morning what attitude we were going to take to each of these applications, and there has been correspondence about it. So on the application to maintain confidentiality, Mr. Natterson has submitted certain documents to the Commission. He's concerned about private and other sensitive information in those documents. The arrangement that has been agreed between the parties is that the documents that we will be working with in the bundles today will not be made publicly available after the evidence. We will engage in a process through the course of the evidence of identifying only those parts to which reference is made in the course of the evidence, and those are the parts of the documents which are relevant to the investigations of the Commission. Certainly as a legal team, we have no interest in publicly disclosing any other information that Mr. Natterson has provided to the Commission. And so the arrangement will be after today's hearing. There will be a process of redaction engaged upon, which will ensure that any documents that were submitted by Mr. Natterson, which have not been referred to in the testimony today, will be redacted, and only that redacted version will be made available on the website of the Commission or otherwise publicly. Chair, as I understand the position, that is a position that is agreed to by Mr. Natterson.
Okay, let me try and understand that. So there will be documents to which a reference will be made in the course of the evidence of the witness.
Yes.
That's not affected by the arrangement.
Correct.
The arrangement only affects documents that will not be referred to during his evidence.
Chair, I should be specific. These bundles contain a host of documents. Only certain of those documents is there any concern about the confidentiality. And as I understand the application, confidentiality concerns are raised in relation to documents submitted by Mr. Natterson pursuant to summonses issued by the Commission for those documents. We will go to those documents, some of them, in the course of today's proceedings. But let me give you an example. Where Mr. Natterson has provided, for example, a bank statement, the bank statement has many line items on each individual page. There are a whole host of those which are not relevant to the investigations of the Commission, and which, from the legal team's perspective, we have no difficulty suggesting to you, Chair, should be redacted.
Yes.
So the idea for the process and convenience of today's evidence getting underway is that when reference is made on a document that has been the product of a summons by the Commission to information, it can then be publicly disclosed. But all else to which no reference is made will be blacked out so that issues of privacy, etc., in those other pieces of information on a given page will not be made publicly available.
But the idea is that whatever documents are referred to today,
yes.
Should not be made publicly available until the process that you talk about has been completed.
Precisely, Chair.
At which stage then they can be made publicly available after whatever reduction has been effected.
Precisely, Chair. And just to give a background to why we've arrived at this, what I'm going to suggest is a pragmatic approach. Chair, you'll be aware that the rules of the Commission require a witness who makes any claim for confidentiality in respect of summons documents to identify with specificity each portion of each document in respect of which a confidentiality claim is made and the grounds on which it is made, There have been engagements between the Legal Commission and the Secretariat of the Commission and Mr. Natterson and his lawyers in this regard. At no point has he provided the Commission with an itemized and specified which portions must and must not. But we did not want to be obstructive, and so our approach and suggestion today is that it's a pragmatic way of dealing with it, as and when reference is made to something in the course of evidence. My learned friend, Ms. Buthelezi, has the unenviable task today of making a very clear record of what those parts were. It will then go through a process prior to being made publicly available of blacking out everything else, and then only thereafter will it be uploaded onto the website of the Commission.
Yes. Okay, I don't have a problem in principle with that arrangement, but once I've had confirmation from Mr. Natterson's legal representative, then I will issue a ruling that should cover that.
Thank you, Chair. And before I hand over to Mr. Pienaar, I will just deal with the application to cross-examine Ms. Tlatsana, because it's appropriate that he deals with both in any address he wishes to make to you, Chair. The application to cross-examine Ms. Tlatsana you will find in the soft file SEQ 13 of 2019. Chair, this is an application that was received on about the 29th of June. When the legal team initially received the application, it regarded it as deficient. And it was deficient in the following respect. Chair, you'll be aware that Rule 3.4 of the Commission's rules requires any application for cross-examination of a witness by an implicated person to identify the parts of the witness's affidavit or statement or testimony which is disputed, and the grounds on which those parts are disputed or denied. Mr. Natterson's cross-examination application identifies the parts of Ms. Tlatsana's affidavit and statement that he takes issue with. It does not, however, in the view of the legal team, identify the grounds on which those parts are disputed. The legal team, therefore, through the Secretariat of the Commission, engaged with Mr. Natterson's lawyers, set that out, and made it clear that in that respect, it was regarded as deficient and invited a supplementation of the application. What we received, I think it was 2 days ago, was a letter from Mr. Natterson's lawyers indicating again the parts of Ms. Tlatsana's affidavit and statement in respect of which they say they take issue and they want to be granted leave to cross-examine, but again failed to set out the grounds. So it is our submission this morning before you, Chair, that it remains deficient. That, Chair, your previous rulings on cross-examination applications have made it clear that you want to be in possession of the two versions in order properly to be able to exercise your powers as to whether it's in the public interest to allow the application. So it is our submission this morning that it remains deficient, that it should be supplemented, and when it is, and in good time, Chair, you will no doubt consider the application and give whatever ruling you deem appropriate. But that is the official stance of the legal team as matters stand this morning. Chair, if I may, there are one or two other procedural aspects to deal with, but not ones that I believe Mr. Pienaar has an interest in.
Yes.
And so I should maybe hand over to him to address you on those two aspects.
Yeah, of course, the cross-examination application should be given to Ms. Tlatsana.
Indeed.
For her to file an answering affidavit or respond if she chooses to.
Indeed.
So that it is ripened for argument. But I think it was important that at least you brought to the attention of Mr. Natterson's lawyers what the view is of the legal team of the application, so that they themselves could then take a view whether
Indeed.
your contention had merits or not, and in due course then I decide the matter.
Indeed, Chair. And if I
Yes,
may
yes.
just pick up on one point. Chair, it's precisely because our processes envisage us giving the cross-examination application to the witness who is sought to be cross-examined for their response, that it must contain the grounds on which it is disputed or denied. Because an application that doesn't tell Ms. Tlatsana what the contrary version is an application that she can do very little with. She can say again what she said previously. And so that is the underlying principled basis, Chair, on which the legal team adopted the position it did.
Yeah.
Thank you, Chair.
Thank you, Mr. Pinar. Please come forward.
Thank you, Chair. Thank you to my learned colleague. Let me first deal with the application for redaction of the record. Ms. Hofmeyer has dealt with the submissions and has advised, Chair, that certain aspects of the record will be redacted due to the sensitivity and the confidentiality of the information on it. That is exactly what we made application for, and we are happy with the outcome. Having said that, I think it needs to be said, stated on record, that we are dealing with high volumes of documentation. The bank statements, by way of example, as my learned colleague says, contain a number of line items which, if one was to go and redact, one would spend an inordinate amount of time doing so. And I think logically, the reverse engineering of that situation would be more preferable. In other words, instead of redacting all the sensitive and confidential information, rather let's focus on what information is relevant for the time being, and we can agree that the balance of the information is redacted to the extent that evidence sought to be led on information which we believe to be confidential or sensitive. We will bring that to Chair's attention, and we will deal with it individually on that basis. Okay. Then secondly,
maybe let me let me deal with the confidentiality. Let me give the ruling on the confidentiality application so that we are done with it. How much time do you consider reasonable in order to complete the exercise, whatever it is that needs to be done? A week?
I think a week would be more than reasonable.
Chair, it can be done in a matter of hours.
Oh, okay.
The bank statements are a few pages. Chair, the envisaged approach is that we have the bundles before us today.
Yes.
The course of the evidence will run.
Yeah.
Reference will be made to parts that are relevant to the investigation of the Commission.
Yes.
Whatever is referenced will be highlighted by my learned friend, Ms. Buthelezi.
Yes.
At the end of today, we will take those files back across the road, and anything that is not highlighted will be blacked out.
Yes. So that will be
That will be the end of
the
it.
process.
I've engaged with the Commission's document management people. They tell me that they are very swift, and that will be done simply.
Yes.
And only thereafter will those documents and the full bundle be made available on the website.
Okay.
That is the process we envisage.
Okay. Mr. Pinar, maybe to be on the safe side, shall I say that the documents will not be made publicly available before end of the day on Monday? Would that give...
Chair, I would like a bit more time. I'm not as optimistic as
Wednesday?
Wednesday would be more preferable,
Wednesday would be
please.
fine. Okay. Documents relating to the witness, Mr. Vivian Nutterson, that have been submitted to the Commission will not be made available publicly until the end of the day on Wednesday next week. That is to enable the Commission's legal team and Mr. Nutterson's lawyers to attend to the process that will ensure that information that is not really relevant for purposes of the Commission is not made publicly available if it's confidential. I think that covers it. Is that fine?
We're happy with that. Thank you.
Okay, thank you. And then let's move to the other application. The other application, of course, is not to be considered in terms of the merits now, because it hasn't reached that stage. But you might wish to say something in response to whatever Ms. Hofmeyer may have said.
Absolutely. Thank you.
Yes.
Firstly, Chair, I'd just like to make a statement that having witnessed the evidence given during the course of the Commission over the past several weeks, it seems to be abundantly clear that there's a reluctance on the part of the Commission to allow the cross-examination of witnesses. Now, the only inference that could be drawn, and please forgive me if I'm forgive me if I'm overstepping the
Yes,
mark,
no, that's fine.
But
Let's
please,
hear.
I need to make the statement.
Let's hear, yes.
The only inference, only logical inference that can be drawn is that the Commission's legal representatives don't wish, and I'm going to use my client as an example, he's an implicated party, don't wish the evidence of the witnesses so implicating to be tested, because they wish for that evidence to be dealt with on a prima facie basis. Now, I understand the purpose of the Commission is to investigate and to collate as much information as possible. But at the end of the day, one must appreciate that my client, in giving this evidence and opening up records, is compromising not only himself, but compromising third parties. It is critical for us to test the evidence. And just as a matter of procedure, the rules of the Commission certainly allow for it. There should be no reason why we shouldn't be entitled to cross-examine those witnesses who have so implicated us. And to take a technical point with all due respect on the basis that the application is deficient. And I understand that there's been a concession that we will have an opportunity to further supplement for that. But at the end of the day, one of the fundamental rules of the Commission is that the witnesses cannot suffer any prejudice. And my submission is simply that without testing the evidence and being entitled to cross-examine, there will be substantial prejudice suffered by my client. But I'll leave it at that. I don't want to belabor the point.
Well, let's not leave it like that, Mr. Pinar. You have just said that it seems to you that there is a reluctance on the part of I don't know whether the Commission or the Commission's legal team to have witnesses cross-examined. What is the factual basis for that statement?
Well, let's take this specific application. I'm told by the legal representative for the Commission that the application is deficient because, one, it fails to set out the aspects of Ms. Tlatsana's statement which is in dispute, and secondly, it fails to give grounds for that. Now, on the contrary, the affidavit submitted in support of the application to cross-examine does quite the opposite. In fact, at paragraph 10 of the affidavit, it sets out specifically the aspects of Ms. Tlatsana's evidence which is in dispute. And
but Mr. Pinar, the Commission's legal team looked at Mr. Natterson's application for leave to cross-examine and took a view. They are entitled to take a view, and not only are they entitled, but probably they are obliged to convey that view to Mr. Natterson's lawyers to say this is what we think, so that you are not taken by surprise later on if they say our view as the legal team is that this application is defective. They took the view that it was defective. They wanted to make sure that you knew that as early as possible, so that if you considered that it was defective, there would be a time for you to supplement, rather than them having taken the view that his application is defective, them keeping quiet and hope that you won't pick that up, and when the application is argued, they come up with that point. You were not obliged to agree with them that the application is defective. You are entitled to say, I don't agree with that, this application is in order. We want to pursue it as it is. You had that right. And you know that in the end, it's not the legal team of the commission that decides whether leave to cross-examine must be granted or not. I decide that. So I don't understand why, if the legal team takes a certain view of the application and they convey that, why that should be interpreted as them being reluctant to have a witness cross-examined.
Well, thank you, Chair. But the reality is they're entitled to take a view, as are we. Our view is obviously
Different.
different.
Yes, and that's in
But
order.
having said that, we've been given the opportunity to supplement by way of correspondence. We have identified the aspects of the affidavit which sustain the disputes and the grounds, and notwithstanding have been told that it's still deficient.
Yes, but their word is not final.
I understand that, Chair.
Yeah, you can disagree with them and
I
say,
am disagreeing with them, and
Yes.
I understand that, but I need to make the point. And I'm entitled to make the point, and so is my client, that there should be no reason why the evidence of Ms. Tlatsana should not be tested. And we should have the right,
that's
bearing
the merits.
bearing in mind that the test is prejudice, and bearing in mind that sorry, and I'm not trying to educate you on the rules of the Commission. You're well aware of the rules. But you are aware, as am I, that the evidence given has to be to the benefit of the Commission and in the public interest. And where would the public interest be served ultimately if my client isn't given the opportunity? And the reason I bring it up here, Chair, is because we have already been told for the second time that the application is deficient.
You see, Mr. Pinar, the part of the arguments you advance to the stage where I will be hearing argument on whether I should grant leave to cross-examine or not, which is not today, you know.
I understand that, but you've asked me to address
Which is
the
not
Commission.
today, yes. And whatever the Commission's legal team may say to you about their view on the application, you are entitled to say, we don't agree and we want the application to be set down for hearing or to be served on the other side because we want it ripened as soon as possible. And if the Commission knows that even though the legal team might have taken a certain view of it, you don't agree, you are happy that the matter proceeds, the matter will proceed. You know, all that will need to be done is that the application be given to Ms. Tlatsana. She gets a chance to file a response. If she chooses to, she might not choose to. And at a certain stage, the application will either be dealt with by me in chambers or it might be set down for argument in an open hearing. And I don't know whether you have had a chance to read some of the rulings that I've made on applications to cross-examine. It should be quite clear from those rulings that there is certainly no reluctance on the part of the Commission to have evidence tested as long as the test is met and all the requirements are met.
Can I put it differently?
Yes.
Okay, if I may. I understand that this is not the forum where the merits of the application to cross-examine will be argued. But let me put it this way. My colleagues have come back and said that notwithstanding our supplementation via correspondence of the application, or our explanation as to why the application is not deficient, is insufficient and it remains deficient in their view. It is for that reason I'm bringing it up now and placing it on record, because I believe that the onus now falls on my colleagues to explain why the information that they've been provided is still deficient.
No, that doesn't have to be explained now. As long as you have taken the view that the application as it is, you take the view that it is in order and should be processed, that's what will happen. That's what will happen. So they've given you the benefit of their view. You have considered their view. You don't agree. You want the application to be processed. It will be processed. That's all.
Chair, thank you. But
Yeah.
I would like to place on record and ask,
Yes.
given the fact that the legal team for the Commission have said that it should still be supplemented, given the fact that we have provided further information and it appears, in their view, to still be deficient, that we be given the opportunity to be provided by the legal team with an explanation of their view as to why it's deficient, so that when we do supplement, and I thank them for the opportunity to further supplement, that when we do supplement, we are meeting the requirements that they are setting out for the application to meet with 3-4 of the rules. That's all I'm saying.
Well, let's get where we are right now. I thought what you were saying amounted to saying the application, as far as you are concerned, is in order. It should be processed. There will be no further supplementation. But the last few statements you have made suggest that you may be wishing to have an opportunity to supplement, depending on what they say to you in explanation of their view.
Chair, if they say that it's still deficient and they give us an explanation for it, then I would like the opportunity to give them the information they still require, so that when the application is ventilated before yourself, that you are given all the information that may be relevant to that application.
Well, then in that event, I won't say it should be processed. You should talk to the legal team. They will deal with your request and the way they will decide to deal with it. At a certain stage, the application should be ripened, and then it will then be dealt with. Okay.
As the Commission pleases. Thank you.
Thank you.
Thank you, Chair. Chair, I'm indebted to you for that guidance in relation to the processing of the cross-examination application. However, there are one or two submissions I'd like to make in response to my learned friend.
Yes.
Because my learned friend's address included an allegation that it is that the legal team has an interest in keeping implicated persons away from cross-examining the witnesses that they have questioned. And it is important, in the light of that very serious allegation, that the legal team's position in relation to this application be set out for the record. Chair, until this point, we've been dealing in some abstraction about what the application contains and what was said. I suggest we don't deal with abstraction anymore. Let's go straight to it. Chair, you'll find the cross-examination application at SEQ 13 of 2019. My learned friend said paragraph 10 of that application sets out and meets the requirements of the rules. Chair, the requirements of the rules, you'll be aware, Chair, with respect, is that in terms of 3.4, an application by an implicated person must be accompanied by a statement from the implicated person responding to a witness's statement insofar as it implicates him or her. The statement must make clear what parts of the witness's statement are disputed or denied, and the grounds upon which those parts are disputed or denied. Chair, it is our submission that you will read this application that was received. You will find in it the parts and identification of the parts of Ms. Tlatsana's evidence that are disputed or denied. What you will not find is the grounds on which they are disputed or denied. My learned friend's reference to paragraph 10 confirms that, because paragraph 10 at page 6 of this application reads, further to the above, add para 4.45 of Tlatsana's aforementioned answering affidavit. She alleges on behalf of Coroneka that I had, quote, business dealings on behalf of certain Gupta-related companies, without further elucidation as to, inter alia, what dealings she refers to, with which Gupta-related companies such dealings were entered into, and on what basis such bold allegations were being made by Klatsana. Not the grounds on which the allegation that he had business dealings on behalf of certain Gupta companies is disputed. Chair, that precipitated a letter from the Commission to Mr. Natterson's attorneys. You will find that in the bundle of Mr. Natterson's evidence. We haven't yet entered it in as an exhibit, Chair. It should be entered in our records as exhibit DD10. And Chair, you will be looking in Part B of Exhibit DD10. Chair, don't want to take you there, but I do want to quote what was said in the letter.
Okay, yes.
Because, Chair, this point that I make now is the point that was made to Mr. Natterson's lawyers. At paragraph 2.1, in italics, the point was made. Mr. Natterson is, in order for the application to be placed before the chairperson for determination, it must comply with this requirement of the rules. It's preceded by a quote of the rule I've just read. Mr. Natterson is therefore invited to supplement his application in order to identify the parts of Klatsana's evidence that he disputes or denies, and, in italics, the grounds on which he so disputes or denies them. Chair, the response to that was a letter from Mr. Natterson's attorneys dated 10 July, in which in greater specificity they identified the parts of Ms. Klatsana's evidence that are disputed or denied. And they continue at paragraph 6 and say, our client's application to cross-examine clearly indicates the relevant aspects of Klatsana's evidence in which she has implicated our client as the basis on which our client wishes to cross-examine her. And accordingly, the application to cross-examine is by no means lacking with regard to, and then they quote, only the first part, the parts of the witness's statement which are disputed or denied. Chair, if we had possibly been able to place a competent application before you, we would have done so today. But we received that 2 days ago, and it failed to address the italicized part of the letter that was sent 2 days before, saying the rules require the grounds to be identified. I understand my learned friend now to thank us for the opportunity to supplement the application, which no doubt will take place in accordance with your ruling. But the suggestion that those steps by the legal team of the Commission are designed to keep implicated persons away from cross-examining witnesses is quite frankly false.
Yes, well, I gave Mr. Pinar an opportunity to give me the factual basis for the statement, and the fact that the legal team conveyed to them a certain contention based on the adequacy or inadequacy of the application simply is not a basis to allege that the legal team does not wish witnesses to be cross-examined. It can't.
Indeed, Chair, and we're indebted for your ruling in relation to the further processing. As I understand it, there will be an opportunity to supplement. As and when that supplementation is received, we can then place it before you.
Well, put it this way. From what you have read to me, it does appear that the legal team has explained to Mr. Natterson's lawyers what their concern is with the application. I think the position is simply that, based on what Mr. Pinar said at the end of his address, it seems that he is not saying the application may be processed.
Indeed.
As of today. He does wish to explore some further discussion with the legal team. So that's what he will approach the legal team, and the legal team will take whatever stance it decides to take. And then at a certain stage, he will have to inform the Secretary whether he regards his application as complete and ready to be processed, and then at that stage it will be processed.
Indeed,
so
Chair.
I think that's where we can leave it.
Thank you, Chair. The final aspect from the legal team's position in relation to applications for examination. Chair, you the evidence that has been led in the aviation work stream.
I think the main reason, actually the only reason why Mr. Kalat was called to come yesterday and give evidence was so that Mr. Lahe and Mr. Mohammed's versions could be put to him.
Indeed.
Because they had taken the trouble to send in their responses to his evidence. And we spent a number of hours here with the evidence leader drawing Mr. Kalat's attention to the versions put up by those two persons and giving the witness the opportunity to deal with their versions. That's what has been happening, and that is what happened as recently as yesterday.
Indeed, Chair. If I may then move to one or two other procedural aspects as the two applications have been addressed. Chair, there's been a lot of movement in relation to Mr. Natterson's evidence. In the course of yesterday, around midday, we received a further affidavit from the firm which compiled Mr. Natterson's company's financial statements. That was made available to Mr. Natterson yesterday afternoon and will form part of the bundle. He was alerted to the fact that it would be included. In addition to that, just after 9 o'clock this morning, Mr. Natterson provided us with a further statement. We have also managed to include that in the bundle, and so reference will be made to all of those various statements or affidavits in the course of the evidence. Chair, before we continue with Mr. Natterson's evidence, I thought it appropriate to do two things. The one was just to locate this evidence in the course of the aviation evidence, because there has been something of a break since we were last presenting evidence to you, Chair. Mr. Natterson's evidence relates to a particular transaction or transactions between the Northwest Government's Department of Transport and South African Express Airways, and then a company that was controlled by the then commercial manager of South African Express Airways called Coroneka. Chair, you have already heard evidence that from Coroneka, certain amounts of money were paid out to an entity called Neo Solutions. And you have also heard evidence already that from Neo Solutions, monies were paid out to Batsamai Investments. Mr. Natterson is the sole director and shareholder of Neo Solutions. His evidence is therefore relevant to tracking the flow of funds that came out of the Northwest Department of Transport, moved to South African Express Airways, into a company run effectively, according to the evidence that's been presented, by the former commercial manager of South African Express Airways, through Neo Solutions, and back to that commercial manager and an entity called Batsamai Investments. So that's where it fits into the scheme. Chair, at the commencement of the aviation evidence, I also made submissions to you, Chair, about the enablers of state capture, corruption and fraud. And it was the legal team's submission that part of the task of this commission is to understand and investigate what those enablers are, because they are what made it possible for our public resources to be depleted and for public good to be used for private benefit. Chair, in those introductory submissions, I also submitted that companies that allow their businesses to be used to hide the source, movement and proceeds of unlawful activities are clearly relevant to the mandate of the Commission in order for us to understand precisely what happened when these events took place, if indeed they did take place in the past. And as I've indicated in the introduction, it's because of the role that NEO Solutions played in those funds that we asked Mr. Natterson to join us today, and we will ask him certain questions. Chair, there is no other substantive application before you today. However, I'm informed by my learned friend this morning that there are certain in limine points that he would like to address to you. Chair, I don't know what they are. He said he'd like to address them to you. I expect that they arrive from certain averments that were contained in an affidavit that Mr. Natterson submitted to the Commission on the 14th of June, which he deposed to the day before. Chair, those averments include various accusations against the Commission, its members of its legal team and its investigators. In the light of the fact that particular accusations are made against me, it is not appropriate that I deal with any of those in limine points if they are to traverse those aspects. And so I'm greatly indebted to my learned friend, Ms. Kabashe, who will deal with those in limine aspects to the extent that they merit a response after Mr. Pinar has addressed you on them.
Okay, thank you. Mr. Pinar?
Thank you, Chair. The only issue which I wish to address in limine is regarding the evidence that has been put forward in relation to the financial statements of NEO Solutions and the alleged discrepancies that are contained in those financial statements. Now, as I understand the rules of the Commission, and specifically 3.2 of those rules, which state, a member of the Commission's legal team may put questions to a witness whose evidence is presented to the Commission by the Commission's legal team, including commissions aimed at assisting the Commission in assessing the truthfulness of the evidence of a witness. The issue I have, Chair, is this. Mr. Natterson, in his witness statements, has not dealt with the evidence relating to the financial statements of NEO Solutions and those alleged discrepancies. I don't know the line of questioning that is going to be taken by the Commission's legal team, but I thought that it may be prudent to address it up front and to state that to the extent that inquiries or investigations or questions are put to Mr. Natterson regarding those financial statements, given the fact that they fall outside of his witness statement, that those questions be disallowed. I obviously defer to the Commission in that regard, but I think it's prudent to raise it now because obviously the line of questioning will initially deal with his first statements and then the later statements that have been filed. But again, they don't deal with the financial documentation, and so I think a view just needs to be taken, please, Chair.
Well, shouldn't you wait until you hear whether a question is put to Mr. Natterson that you feel is objectionable?
I'm happy to do that.
Yes.
Okay. Thank you.
Okay.
Thank you, Chair. Ms. Kabashe, thank you so much for being here in the event that the need arose. It seems it has not. Chair, we then are ready to proceed with the evidence of Mr. Natterson, if I could request that he be sworn in.
Thank you. Please swear him in or administer the affirmation.
Please state your full names for the record.
It's Vivian Natterson.
Do you have any objections to making the prescribed affirmation?
No.
Do you solemnly affirm that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you.
Thank you.
Thank you, Chair.
You may proceed.
Mr. Natterson, just to orientate you with all those files you see in front of you on the desk, there are 2 files which comprise the various statements, affidavits, and other documents related to your evidence, in particular today. Chair, if I may ask that Mr. Natterson's bundle be entered into the record as Exhibit DD10.
I see you have got A and B.
Indeed, Chair. Thank you.
The one that should be A has got a statement of his in terms of Section 204 of the Criminal Procedure Act at the top. Is that right?
Indeed, Chair.
The liver arch file containing Mr. Natterson's statement in terms of Section 204 of the Criminal Procedure Act on top will be marked Exhibit DD10A. And then the liver arch file, which contains additional annexures, that is in addition to annexures that are in Exhibit DD10A, will be marked Exhibit DD10B.
Thank you, Chair. And then, Mr. Natterson, in addition, in front of you are 2 bundles related to the evidence of 2 previous witnesses. There will be occasion twice to refer to them, and that's why they're available to you. And then the last bundle before you is a bundle containing relevant legislation to which reference may be made in the course of your evidence. But I will identify them by what appears on their spine labels, so you'll easily be able to know what to have in front of you. Mr. Natterson, I'd like to commence your evidence with a bit of background about you, if I may. I read in your affidavit to the Commission that you describe yourself as a businessman with substantial experience. Can you please give the Commission a sense of what that experience entails?
I run a company called Neo Solutions, which is a consulting business, and we do various projects, mostly logistics, transport, advisory, and a lot of information technology.
Thank you. And I understand that you are a chartered accountant. Is that correct?
That's correct.
And where did you serve your articles?
At Deloitte.
And what position did you were you elevated to at Deloitte?
Partner.
Partner. And when did you leave Deloitte?
In 2003.
Are you a member of the South African Institute of Chartered Accountants?
Yes.
And when were you registered with them?
On completion of articles in 97.
So that would mean you've been a member for about 22 years, is that correct?
Yes.
As a chartered accountant, are you aware of the Code of Professional Conduct of Chartered Accountants?
Yes.
And are you aware that it applies to chartered accountants whether or not they do auditing work?
Yes.
So as I understand that code, you would be described within the code as a chartered accountant in business. Is that also your understanding?
That's correct.
I also understand that code to envisage that if there is any contravention of or failure to comply with requirements of the code, that may constitute an offence, and that steps can be taken by SAICA in accordance with its bylaws if a member of SAICA is found guilty. Is that also your understanding?
Correct.
And in terms of the requirements of the code for the conduct of a chartered accountant in business, the code, as I understand it, requires a chartered accountant in business to prepare or present any information for which he is responsible fairly, honestly, and in accordance with relevant professional standards, so that the information will be understood in the context. Are you aware of that requirement?
Correct.
There's a further requirement that a chartered accountant in business shall take reasonable steps to maintain information for which the chartered accountant in business is responsible in a manner A, that describes clearly the true nature of the business transaction assets or liabilities, and C is the one I'm interested in, represents the facts accurately and completely in all material respects. Are you aware of that obligation?
Yes.
Then in terms of Neo Solutions, if we may, just your role there. I indicated earlier in my address that your evidence indicates that you are the sole director and shareholder of Neo Solutions. Is that correct?
That's correct.
Has that always been the case?
That's correct.
And when was the business started?
In 2003.
So it was a move from Deloitte then, where you occupied the position of partner, to the creation of Neo Solutions.
Correct.
And you've maintained the position of sole director and shareholder to this day.
Correct.
Thank you. Mr. Natterson, before I forget, in the early part of 2016, the 4th of January to be precise, I understand from your affidavits and various statements that you were out of town. You weren't in Johannesburg, as I have it. Is that correct?
I think so, yes.
Okay. If it becomes relevant, we'll come back to that, and you can try and refresh your memory more accurately. But at the moment, you say you think you were out of town. Do you recall where?
I normally go away to Cape Town in December.
Right. So 4th of January, you might well have still been there. Is that correct?
From what I recall, yes.
Mr. Natterson, I'd now like to take you to page 21 of Exhibit DD 10A, if I may. Mr. Natterson, you'll see that that is a document entitled Witness Statement, Vivian Natterson. We will come back to this statement, its origins, how it was produced, etc. All that I'm interested in the moment is the description given at paragraph 1 there about the business of Neo Solutions. You indicate at paragraph 1 there that the business provides the following services, and then they're listed in 6 sub-paragraphs. Is that an accurate description of Neo Solutions services?
Yeah, I think it covers most of the things we do.
As your evidence, I had it earlier, you said in general it does advisory and consultancy work. Is that correct?
Mostly in the areas of business process re-engineering and technology.
Right. And to whom are those services generally provided?
A mixture between private sector and government.
Does Neo Solutions produce any goods or products?
Sometimes we do, to the extent that there is technology required for an implementation of a project.
So would it be fair to say it's confined to technology products?
No, there's quite often if it's beyond technology, there's software, which may be considered technology, but
Right.
generally, yes, that.
Has Neo Solutions ever been involved in the manufacture or procuring of security camera equipment?
On some of the rollouts, we do provide CCTV equipment, which some of the implementations we do require CCTV on it, so they become incidental to the project rollout.
Have you ever provided, as Neo Solutions, security camera equipment to airports?
No.
Is Neo Solutions an accountable institution under FICA?
No.
Is it a financial services provider?
No.
Is it a deposit-taking institution?
No.
So it doesn't hold money for third parties like a bank would and then make those funds available to them as and when they want them?
No.
Did Neo Solutions ever render invoices to Coroneka Trading and Projects for security cameras that it provided?
Definitely not.
And did Neo Solutions ever render invoices to Coroneka Trading and Projects for any services at all?
Definitely not.
Did an entity called Batsamai Investment Holdings ever render any services to Neo Solutions?
No.
And did Neo Solutions ever receive any invoices from Batsamai Investments?
As far as I can recall, no.
Mr. Natterson, if you had received such invoices, and you'll correct me if I'm wrong on this assumption, I assume you would have sent them back and said, I don't know what these are about because Batsamai, you haven't ever rendered any services to Neo Solutions. Is that a fair assumption to make?
I think in the context of the relationship with Mr. Van Wyk, as the invoices would have been incorrect because the funds were received from him as a proceeds from a project that he had told me about. But I think that will come out in the context. As it stands right now, no, we would have queried invoices that would have come because they shouldn't have been invoices.
Okay, let's unpack that a little bit. What is your evidence as to whether invoices were ever received by Neo Solutions from Batsamai Investment Holdings?
Okay, so can I refer to
Of course.
my statement? Okay, the document.
I will need to give a reference to the chair so that we can find the pages. So if you direct me to where you are, sort of, in the statement, I'll be able to guide us.
Okay, I think if I go to
It looks like a transcript of some conversation between.
I think it's page 238.61.
What is the page number?
238.61.
238.61.
Yes, Chair, apologies. Those are, what you were picking up right at the end are annexures to the statement which arrived this morning. If you go back to 238.61, I'm indebted to you, Mr. Natterson. You were a bit quicker than I was. But that's the statement you provided this morning.
Yes, I've got it.
Mr. Natterson, you wanted to draw our attention to something here.
Yeah, so I think it's important that I contextualize the relationship with Mr. Van Wyk and how it evolved before I can get to the answer of exactly whether the statement, whether there were invoices or not around this matter.
Mr. Natterson, if that is your intention, then I'm indebted to you for that clarity. I do suggest then we get to it in the course of unpacking that relationship, because I have a series of questions that will get us there. But
Okay.
I won't lose the point that in the course of that, I'd like you to clarify as to whether any invoices were received from Batsamai, and if they were, what approach you took to them. So
Okay.
let's do it in
So
the
shall we
course
come
if we
back to
may.
that? Okay.
Indeed. And certainly if I don't remember, I'm sure your legal representative will remind me about it. Mr. Natterson.
What happens to the question you had asked, which he wanted to answer? That's
Indeed.
when he took us to the statement.
Indeed, Chair. And my suggestion, with your leave, is that we get to it at the appropriate point in the
Okay.
development of the story.
Okay.
What I was seeking to do at this stage of Mr. Natterson's evidence was just some background as to the nature of the Neo Solutions business, as well as his own background.
Yeah,
I
that's
think
fine.
it appropriate to deal with it when we get into the meat of the transaction.
That's fine.
Thank you, Chair. I'm indebted. And just to conclude on the business of Neo Solutions then, has Neo Solutions been involved in beef farming?
No.
And has it been involved in conducting feasibility studies into the possibility of beef farming?
We actually do a lot of feasibility studies for various sectors, and we guide a few clients along that. So beef farming happened to be one of them.
Right. So it is not doing the beef farming, but it provides advisory services in relation to feasibility of certain ventures. Is that a fair summary?
Correct. We have a team that puts together the feasibility studies, and where there's specialist services required, then we bring those in to assist.
And in relation to beef farming in particular, when did Neo Solutions engage in that work?
In terms of the feasibility study for that project, again, it'll come out in the context of this because we do have to deal with it in there. But ultimately, Chair, just to give you a picture, when I created Neo Solutions, that was in 2003, we stuck to our roots as a core business of consultancy as Neo Solutions. but there is a bigger group that are intended at the start to evolve to. And like any good consultant, you dream of the day that you don't want to sell time anymore. And the intention behind creating feasibility studies where the group, as Neo Africa would be the ultimate shareholder, was to again move away from selling time to going into businesses that are annuity-based. So yes, the feasibility was being conducted by Neo Solutions, but the intention was to create a business unit under the group that would then give effect to this long-term business.
Thank you for that background. My question was, when did that take place?
That started during towards the end of 2015, on about October-ish.
So it wasn't related to when you became a director of a company called Dista Farming Operations?
The intention, obviously, was to institutionalize. So when the business was then successfully funded and implemented, then Dista Farming would then be the enterprise that we were going to label it under.
Right, but as I have your evidence, those feasibility assessments started well in advance of that.
Yeah, so just again to give you context to that, we were also assisting a couple of retail chain stores in terms of their identifying new convenience center sites. And we then saw in there that the empowerment or the lack of empowerment in supply chain into chain stores was a big gap area that we could intervene into. So the intention was not to buy farms only. We had no intention of just being farmers. The intention was to create a supply chain logistics enterprise that will go from farm to fork, which ultimately means that our first prize was to secure offtake agreements and obviously leveraging off the BEE nature of the company to be able to get into the chain stores for delivery of goods such as meat, etc. And secondly, to identify foreign offtakes, because we believe that there would have been an opportunity in that space. So the whole feasibility study was actually based on securing offtake agreements first and reverse engineering the entire supply chain so that we will have the farm, have the abattoir, have the meat packing, and then ultimately the delivery of the business.
Mr. Nasson, as I understand that answer, you said Neo Solutions was not just interested in investing, but at least in some respects it was interested in investing in farmsteads, abattoirs, etc.
Don't
Is
get me
that
wrong,
correct?
I'm saying it's not limited to farming,
Indeed.
although we loosely use the word throughout called farming, but the enterprise that we were seeking to implement was an entire logistics enterprise starting from the feedlot and ending at the distribution point. It was not just to buy farms.
Understood. Thank you. Mr. Nasson, I'd then like to go through the various affidavits and statements that will be relevant to your evidence, just so that you can understand where they are, navigate them, and I'd like to ask just a few questions of an introductory nature in relation to them. We can start with the Section 204 declaration that you made in October 2017. You'll find that in DD 10A from page 3. Can you confirm that that is your Section 204 declaration? If you go to page 11, it may be useful because that contains what I understand to be your signature. Can you confirm that it is your signature?
Correct, it is.
Thank you. Just before we move beyond this, can you tell us a little bit about the circumstances that gave rise to the production of this statement? Who did you meet with in its production?
Okay, so again, its context is now, there's a lot of stuff that's happened before, so I don't know if you want to deal with it exactly at this point.
Let's just deal with who did you meet with to produce this statement?
So, the investigator that was appointed by Coroneka approached me to state that there was indications that Brian van Wyk was in fact the one that hijacked the company and not the other way around. Up to that point, Chair, the indication that Brian had always given us was that the company was hijacked by his partner. And the investigator that was then appointed approached me in around September 2017 to state that it was in fact Brian that did it, and that this lady who was his partner, I didn't know the name at the time, was in fact the one that had opened up a counter case, and that on that counter case they were seeking to recover monies back to the company from Neo Solutions, because we were in receipt of those monies. So at that point, I explained to Jan Udil, the investigator, that we had done nothing wrong. We had, in fact, Brian had transferred these funds on the basis that it was a dividend or proceeds from a project that he had in the Northwest Province. And on that basis, we had taken his money in good faith. The intention was to invest in businesses. He had indicated that before this, he had indicated that he was planning to leave SA Express and that these funds had nothing to do with SA Express. That the intention was obviously to set up businesses for when he was out of SA Express. The farming venture happened along the same time as when he approached us. So when he heard us discussing the farming venture, he then wanted to be part of it. And in fact, it was, and you'll see through our evidence that a lot of the feasibility study of the farming venture was actually done with Van Wyk directly involved. But going back to this point, when the investigator approached me, I then said, we obviously will cooperate because we weren't aware that there was something untoward with these funds. And then I tasked the investigator to work with my accounts team to obtain the bank statements, the proof that whatever we had received from Van Wyk, purportedly as a dividend from Coroneka, was in fact returned to him. And we then provided all this information. And the Section 204 was then prepared on that basis.
Who prepared it?
So exactly like we've done here, is that when Udil approached me, I then gave him everything that had happened and what had happened between Van Wyk and myself, and then I referred him to our accounts team. Then he obtained the bank statements, etc., from the accounts team. He then prepared this draft, which he came and sat with me, and then we obviously then agreed it, and I concurred with it, and that's the affidavit that I deposed.
Was Mr. Udil employed by the police service or any official body?
My understanding is that he was a former police officer and that he was appointed by Coroneka to assist in the investigation.
So at the time he was a private investigator, correct?
Yes.
Did it strike you as odd that a private investigator was getting you to sign a Section 204 declaration?
The indication that he gave me was that the investigating officer, and he did put her on the phone, the investigating officer was based in Rustenburg. And for logistics reasons, she couldn't come across to us, and therefore he was facilitating getting this done.
So I wasn't aware of that before. So there was actually a situation in which she was on a phone while you and Mr. Udil were working on the information. Is that correct?
Correct. He briefed her as well.
Do you recall her name?
No, I don't recall her name.
If I said Captain Mokosi, would that ring a bell?
No. I don't recall.
Certainly. But definitely somebody who was introduced as an investigating officer was on a call where you were dealing with Mr. Udil. Is that correct?
Yes.
And you indicated, as I have it earlier in the evidence, this happened around September 2017. Is that correct?
Yeah, the affidavit was finalized in early October, so
Indeed.
it was towards the end of September. It took a few days to get the information together, but it happened very quickly that he got it, and then that's the last I heard of it for a while, actually, since then.
And that is, the date appears at page 11, the 4th of October 2017. Is that accurate?
Correct.
And Mr. Nash, I have your evidence. You sat down with him and you considered what was contained in this document. Did you do so carefully?
When I explained to him what had exactly happened, he obviously prepared it based on what he said was factual. So when I asked him, do we not need more detail than this? Then he said, no, stick to the facts because that's what we need for the evidence to be provided back. He based the whole affidavit on the fact that we had sufficient proof to show that whatever we had received, we had reimbursed to Van Wyk, and that we had not benefited in any way. So he kept it to that content, literally.
And do you today confirm the contents of this declaration?
Yes, I think to the extent that it contains the meat of the information, it's there.
Well, let's just probe that a little further, because I understand your answer to say it contains the meat of the issues. Your affidavit before the Commission, which you deposed to on the 13th of June, describes it as follows, and so you can follow it. You can go to page 66 in the file in front of you. Chair, that's Exhibit DD10. A.
Did you say 66?
Indeed, Chair.
Thank you. Yes.
Chair, I am conscious of the time. If I may just complete this point, we're just at 1:15 with your leave.
Yeah, that's fine.
Thank you. Mr. Natson, if you pick it up at page 66, paragraph 14, you'll see in the second half of that paragraph, you say there, I note that in compliance with Section 204 of the Criminal Procedure Act, the Section 204 statement, that's the one we've been looking at, provides all the relevant details of my possible involvement in the matter candidly and fully, as also, I think it's supposed to say, and also attaches all the relevant proof of the details therein disclosed. Do you see that?
Correct.
Do you stand by the fact that the 204 declaration therefore sets out candidly and fully all indications of your possible involvement in the matter?
I think, to me, when I sat with Udil and I gave him all the information, his advice was stick to just the facts that show that the funds that were received did in fact get reimbursed to Funrec. Obviously, since the interaction with the legal unit of the Commission, there's a lot more information that you are seeking to put in. So I understand, yes, whilst the statement is there, it's relevant to the funds flow in and out, 100% it is compliant with that. The Commission obviously is requiring much further context, and that's the nature of how this entire matter has evolved since the engagement with the Commission since March of this year.
Mr. Natson, why didn't you set that out in paragraph 14?
Again, I think the understanding was on the basis that the fact was we received these funds, we received them in good faith, we returned them to Funrec. That was the essence of my interaction with the Commission's investigative unit at the time. It's only when the Commission started to request much more detailed information that we started to compile that and put it into context. A lot of the information that we further provided later was to give further context to the 204. So yes, although we say all is relevant in that we received these monies, we paid out these monies, there's evidence to support each side, now we're providing further evidence to support what we've put into that document.
Ms. Natson, this affidavit that we're looking at was deposed to on the 13th of June, is that correct?
I think so, yes.
I can take you to the end if you'd like. You'll find it at page 75.
Okay,
That's the 13th of June this year, is that correct?
that's right.
By that stage, you'd have had all the interactions that you're speaking about with the Commission, hadn't you, other than today?
Yes.
So when you sat down to prepare this affidavit just before the 13th of June, you'd had all of those interactions, you knew how much more the Commission was interested in, and then why did you say at paragraph 14 that your Section 204 statement provides all the relevant details of your possible involvement in the matter candidly and fully, if, as I understand your evidence today, you accept that it doesn't?
Sorry, if I may just
Yes, please
interject.
come forward.
I'm sorry.
The person next to you can just switch off your mic at the back so that, yeah, okay.
I'm sorry, Chair. I think Mr. Natterson has answered this question twice. He's explained the context in which the affidavit was given to UDEAL. He's explained the request made to him at the time by UDEAL and the guidance that was afforded to him by UDEAL in making the statement. Since then, my learned colleague is well aware that my client has furnished numerous further statements, clarifying, supplementing. There's no need to take the line of questioning over and over because we're not getting anywhere.
Why is that not an answer that should be given by Mr. Natterson?
He's answered it twice.
Yeah, well, I haven't heard the part that you have just said about how much more else he has given.
Chair, we are focusing on a 204 statement. We are focusing on UDEAL's statement. We are reading the two in the context of one another. It's clear that when my client sat with UDEAL, he was asked for a very specific statement. He gave that statement at the time. Subsequently, he's given further statements which amplify and provide all the further information requested. But my learned colleague is pressing on this point almost...
But my understanding of the question arises from the fact that in paragraph 14, he says that the witness that the 204, the section 204 statement contains, provides all the relevant details of my possible involvement in the matter, candidly and fully.
But Chair,
Yes.
Mr. Udil was appointed by Coroneka. So his request related to his mandate that he's received from Coroneka to investigate the matter and to secure evidence. Therefore, the evidence that he had requested would have been constrained by that mandate. So at the time, the information that was provided by my client to Mr. Udil in the 204 was limited to the inquiries made.
No, I think that point I understand, but I think this seems to go beyond that. It seems
I think
to say,
we're focusing on wording in the affidavit.
yes.
Most affidavits contain a generic statement to the effect that the information contained herein is, to the best of my belief, true and correct. It's comprehensive of the information relevant to the matter. That does not mean that is the only information that may be relevant to every aspect of every transaction leading to the statement taken by Udil. So my point is simply, and I don't want to belabor it because
Yes.
I understand we time constrained,
Yes.
but I think to focus on that specific wording when Mr. Nuttison has twice explained the reason the words were inserted into the affidavit to the effect that that was everything, all conclusive, it's not taking us anywhere. With
Look,
all
I
due
want us
respect.
to have progress. I think if I understand Ms. Hofmeyer's question, it relates not so much to what the statement relates to in regard to the Section 204 statement as such, to what the private investigator wanted. It seems to relate to what Mr. Nuttison understood in June 2019, to his involvement to have been in the matter. And to the extent that in this paragraph, he was looking back at the statement of Section 204.
Correct.
And in June saying that statement relating to Section 204 fully and candidly describes his involvement in this matter, which that's the understanding of what she is trying to look
I
at.
appreciate that that's the
Yes.
understanding.
Yes.
But the reality, that may be the understanding now, but the reality is that the 2019 statement referred back to the 204 statement. The 204 statement was specifically contextualized and specified the involvement of NEO in relation to the Coroneka funds, and it was very specific. To now say that the statement that you gave was purportedly all-encompassing, you've said that under oath in the statement, and why did you not mention any other factors or any other issues or any other related entities, transactions? I think my colleague is well aware as to why.
Well, Mr. Pienaar, let me just read to you the first sentence of paragraph 14. Moreover, the aforementioned correspondence from APAA advised that any and all evidence that I could offer the Commission was already in my Section 204 statement, which forms part of the public record and is also being used in a criminal investigation.
That is correct, Chair.
So I read this to say, in June 2019, when Mr. Nuttison was doing this statement, he was saying that the 204 statement contained all that he could offer as far as the Commission is concerned in terms of his involvement.
Correct.
Which, from what I have heard now from him and from you, seems not to be correct, because both you and he have said that he has subsequently supplied a lot more information.
He has supplied information
Yes.
requested by the Commission's legal representatives pertaining to the ancillary transactions and individuals involved. And the request that has been made continuously is, what do you know about these ancillary transactions and persons?
Yes, Mr. Pinard, I'll allow the question. Thank you.
Thank you.
Mr. Natterson, do you recall the question?
If you can repeat it, please.
Certainly. If we just go to page, I think it was 66.
Yeah, I'm on 66. So you're referring to clause 14.
I'm referring to paragraph 14 on page 66. And I was focusing on the second sentence in that paragraph. And I was asking you, in the light of your evidence, why you didn't say there something more along the lines of the testimony you've given today, which is that the Section 204 statement didn't set out all the dealings and possible involvement that NAO Solutions had in this matter, that there is more, that you furnished more to the Commission, and you're ready to come to the Commission to say that. Wouldn't that have been more accurate?
I concede it would have been more
Thank you.
accurate.
Mr. Natterson? Oh, Chair, I realise we have missed the tea adjournment.
Well,
May be appropriate.
we may as well go up to past.
Indeed.
But if you're moving on to another point, we could adjourn now.
Chair, I was going to move on to some of the other documents, so maybe we should adjourn now, and then I can move beyond this statement.
Okay, we'll adjourn now. It's 25 past. We will resume at 22:12. We adjourn.
All right.
proceed.
Thank you, Chair. Mr. Natterson, before the break, we were looking at paragraph 14 of your affidavit dated the 13th of June 2019. That affidavit concludes at page 75. We looked at your signature on the date of the 13th of June there. Ms. Natterson, can I just understand, other than the correction that you've now made to paragraph 14 of this affidavit, do you otherwise confirm today that it's a true and correct reflection of the facts set out?
I think, Chair, it might be useful if I can also clarify the engagement that has happened with the Commission.
Well, before you do that, I think you might wish to rephrase your question. You said you wanted to confirm that it is true and correct in respect of the facts set out.
Indeed.
I don't think that's accurate. You want to rephrase that?
Indeed. Mr. Natterson, if we go to page 56 of your page 56, which is the first page of that affidavit, paragraph 2 there says the following: the facts herein contained, save where otherwise stated or where the contrary appears from the context, are within my personal knowledge, and are, this is the point I'm interested in, to the best of your belief, both true and correct. As you sit here today, do you confirm that that is the case again?
Again, Advocate, and through you, Chair, the evolution of the discussion. So I was contacted by the Commission's investigating unit in March of this year. In that first interaction, I presented the 204 when they explained that it related to the Coroneka payment to us. And then since then, there's been an evolution of providing further information, etc. So you'll see from the evidence, there's several affidavits by me as we pick up evidence and to support or to provide further background to the original 204 affidavit. So ultimately, yes, at each point in time, I then, especially in the context that the company, yes, I'm the sole director and the shareholder, but I'm also very operational on every single project. And a lot
yes, Mr. Natterson, I think you might be too cautious as to how you answer the question. But the question that Ms. Hoffmeyer is asking you doesn't relate or is not the same as the question she asked you in relation to paragraph 14. All she is asking is whether, as you sit here, you are able to say the contents or the facts you have set out in this affidavit are, to the best of your knowledge and belief, true and correct. That question says nothing about whether it's all the facts and so on. It doesn't say anything about that. It's simply whether the facts as you set them out in this affidavit at the time you did this affidavit. As you sit here, when you go through the affidavit, are you in a position to say, to the best of your knowledge and belief, they are true and correct? That's all she's asking.
Okay. Chair, thank you, Chair. At that point in time when I signed this affidavit, I concur with that. Since then, there's been further developments where I've obviously received further information which required me to then amend and correct, which is then supplied in later affidavits, including the one of this morning.
I guess your answer, therefore, is that as you sit there now, you are not able to say all the facts you set out in that affidavit are to the best of your knowledge and
correct.
belief.
At that point in time it was, but there was further
thought.
evidence that's come out or further changes or supplementation that was needed.
Okay, all right.
Mr. Natterson, you mentioned that as a consequence of further information, you had provided a further statement or affidavit. Is that the one of this morning?
I think that's the most recent one this morning, correct.
There's no other one to my knowledge. Do you know of another one?
No.
Right. So are we then to understand that the statement that you provided this morning is the version that we must apply for the purposes of your evidence, and any contradictions between what is in the 13 June affidavit and the statement of this morning must be read that what you confirm is true and correct is the statement of this morning?
Can you repeat the question?
I
Maybe
just want to
let's-
know which
maybe-
version.
Maybe let's put it this way. If you look at the two statements, the one that you supplied this morning and the one of June, which one do you say correctly and fully sets out the facts in relation to your involvement in this matter?
The statement of this morning.
And what do you say about the statement of June? Do you say it should be disregarded, or do you say it must be read together with this morning's statement? In other words, it is possible that your statement of this morning captures everything you want to put before the Commission, and the one of June you regard as inadequate, in which case you say, even if you don't look at the June one, if you look at this morning's one, I'm happy it has everything. Or you might say, well, the two must be read together because there are some things in the June statement that I haven't repeated in this morning's statement that must still be taken into account.
Okay, Chair, I think the statement that I submitted this morning adequately reflects all of the information I intend to provide.
Does that help?
It certainly does, Chair, but there is a follow-up because there are a number of aspects that are traversed in the 13 June affidavit that are not taken up in this morning's statement. So I need clarity from Mr. Natterson. In the respects dealt with in the 13 June affidavit that you do not deal with in this morning's statement, do you confirm today that those other aspects of your 13 June affidavit that you deposed to under oath are still true and correct?
Chair, could I consult with my legal advisor, please? I'm unsure of whether one concession or the other, how it affects my testimony.
Well, remember that all you have to do is you have got to give an answer that you believe, to the best of your knowledge and recollection, is the truth. Okay? Now, before I come to the question of your request, as I understand the question, all that it requires you to know is whether there are some things in the June statement that are not in this morning's statement, and whether those things that are in the June statement but not in this morning's statement are correct or not factually. Is that what you want to?
Yeah, if we've made
advice
corrections to I don't recall the exact content offhand against each other right now.
Yes.
But to the extent that the current statement corrects anything that might have been deficient in the
Yes.
original statement, then I agree we can reconcile them.
Okay. So it may well be that if and when the time is right in terms of your planning, you might have to be specific.
Indeed.
Yeah.
Indeed, Chair. And in fairness to you, Mr. Natterson, I fully understand, and just so that we're on the same page, I want to clarify this with you. I understand that if you said something in the 13 June affidavit, which you now take up in the statement of this morning, you want us to regard the statement of this morning as correctly setting out the facts. Is that correct?
Correct.
Fine. But there are matters in the 13 June statement that are not taken up, 13 June affidavit, that are not taken up in the statement this morning, I assume, because you had no need to correct them. And on that basis, I'm asking you today, do you confirm that those other aspects are true and correct?
Correct.
Thank you. The next affidavit I'd like to just take you to for orientation purposes, because I will make reference to it in the course of the evidence.
Sorry, Mr. Natterson, I didn't go back to your request to consult your lawyer simply because it looked like
I think we covered it.
yeah, okay, thank you.
Thank you, Chair. If you go to page 121 of bundle DD 10A,
I think soon. We will take just a short adjournment. We'll resume at 12 o'clock. We adjourn. proceed.
Thank you, Chair. Mr. Natterson, before the adjournment, we were at page 121 of Exhibit DD 10A. Do you have that?
Correct.
Mr. Natterson, that is an affidavit deposed to by Mr. Madlala. Do you see that?
Yes.
Our records indicate you were sent that affidavit on the 25th of June 2019. Is that correct?
Yes.
I'm sorry, I missed the page.
Apologies, Chair. It's 121.
121, thank you.
Chair, we were confirming with Mr. Natterson that this is an affidavit of Mr. Madlala. He is
Yes.
an investigator of the Commission. And we were confirming that that affidavit was sent to Mr. Natterson on the 25th of June. And Mr. Natterson, I understand your evidence to be you confirm receipt of it.
Correct.
Did you read it?
Yes.
You were also sent an audio recording of the first meeting that you had with the Commission on the 15th of March. Is that correct?
Correct.
Did you listen to that audio recording?
Yes.
Do you confirm that it's your voice on that recording?
Yes.
Do you confirm it's an accurate recording of what transpired at the meeting?
Yes.
Then if we can go to your further statement of this morning, just to orientate ourselves, we looked at it a moment ago. That's at 238.61 in the same file, which is DD10A.
Yes.
It is headed a witness statement, but it appears to have been deposed to as an affidavit.
Okay, I'm sorry.
Apologies, Chair.
I'm at 238.1. That's
Apologies,
on
it's
page
0.61.
Oh, 61. Okay, thank you. I've got it.
Thank you, Chair. I was just noting it's headed a witness statement. However, it does appear to have been deposed to before a commissioner. The only purpose of drawing that observation is to have you confirm under oath today the contents of this affidavit. I'll refer to it as your affidavit of this morning. All the facts are true and correct. Is that right?
That's right.
Thank you. And then we move to the affidavit of Mr. Patel that was received yesterday. Chair and Mr. Natterson, you'll find that at page 238.1. Chair, where I think you were previously.
That's where I was. Yeah.
Indeed. That is an affidavit by Mr. Patel. That was sent to you yesterday. Is that correct, Mr. Natterson?
Yes.
Have you read that affidavit?
Yes.
Thank you. And then the last document I'd like to take you to is the statement that we actually looked at for the description of NEO Solutions business operations. You'll find that at page 21. That's in Exhibit DD10A, page 21. You'll see that statement commences at page 21 and it comes to its end before its annexures at page 29. If you'll turn to page 29.
Okay.
Is that your signature on that page?
Yes.
Did you read this statement before signing it?
Yes.
Did you sign it to confirm that its contents were true and correct?
At time, yes.
Thank you. Mr. Natterson, if we then go back to your 13 June affidavit, which you'll find commencing at page 56 of Exhibit DD10A. Mr. Natterson, one of the aspects of this affidavit that is not picked up in your affidavit of this morning are all your interactions with the Commission's investigators and legal team. Is that correct?
Yes.
You've confirmed already under oath that you stand by the version of those factors set out in the 13 June affidavit. Is that correct?
Yes.
Mr. Natterson, I need then to put to you that there are numerous statements in the 13 June affidavit that are false, and I'd like to take you to them. The first is that you indicate that you had 2 meetings with the Commission, and you'll find that at page 57. At page 57, you indicate that there was a meeting held on the 15th of March, and then you indicate that there was a meeting held on the 6th of May. You later in the affidavit talk about a scheduled meeting for the 10th of May. But as I read the affidavit, you indicate that only 2 meetings were held with the Commission. Is that correct?
I do hear, but I had forgotten about the one in April.
So shouldn't you have indicated earlier that you wanted to correct this affidavit on that basis?
In my further affidavit now.
No, remember earlier I asked you to confirm that the facts that are not addressed in the statement of this morning are facts that you regard as true and correct. But you're now telling me you're not satisfied that there were only 2 meetings with the Commission. Is that right?
I had forgotten about the 16th April, I think it was 16th April meeting.
No, it was the 23rd of April, but so be it. So you accept that there were 3 meetings and not 2?
Yes.
If we then go to page 64,
Sorry, Chair, I may just ask a question, please. What is the relevance?
Please come forward.
Sorry, Chair, I'd just like to understand the relevance of that line of questioning, because it seems to me as though the Commission's legal representatives are simply trying to cast aspersions as regards to the bona fides of my client in deposing to these affidavits. He's made it clear that there was an error on his part in disclosing the April meeting because he had forgotten about it. And then we simply move on to the next point. So I don't know if the intention is to simply take our client now through the affidavit and raise every inaccuracy, discrepancy in order to cast these dispersions. I don't understand the relevance. Perhaps
Well, your client has deposed to, or has signed certain statements setting out certain facts. The evidence leader is entitled to put questions to him, and obviously it's important that the Commission gets the correct picture, and all that has been said at this stage is that Mr. Natterson in the statement indicated only 2 meetings, and yet there was another one. He has conceded that yes, there was a third one, he had forgotten about it. And then the evidence leader, as I understand, has moved on to go to something else.
I understand that, Chair, but my concern is that the line of questioning isn't relevant. It's to simply
Mr.
clarify.
Pinard, how can you say that?
Because
obviously, it's
I can say
it's highly important that the Commission should know what the true facts are.
certainly, but it's
If there were
not
3
relevant to-
meetings, if there were 3 meetings, and the statement says there were 2 meetings, it's important that the Commission should know there were 3 meetings, and he concedes that he has no problem with
I
that.
understand that, Chair, but the meetings were with the Commission.
Yes.
Those meetings, whether there were 2 or 3, is not relevant to the issues which Mr. Natterson is being brought to testify on.
Well, the evidence leader is not there yet. You know, when you ask questions, you might be laying a foundation
I
for
hope so.
something later.
I hope so, Chair.
So I don't think there's anything wrong really at this stage. And Mr. Natterson has conceded, yes, there were 3 meetings. I forgot about the 3rd one.
That's fine. I reserve my client's rights to take the issue down the line if there is no relevance to this line of question.
No, that's fine, Mr. Pinard.
Thank you, Chair.
Thank you.
Ms. Natterson, if we can then go to page 64, and we pick it up at paragraph 9 on that page, you say there, in accordance with the discussions in the aforementioned meeting between myself and the representatives of the Commission, a further meeting between myself and the representatives of the Commission was scheduled for 10 May 2019. Do you see that?
Yes.
Do you know that that is false?
No, I don't recall that that is false.
So you recall there as being a further meeting scheduled?
As far as I'm aware, yes.
I can take you to the email that makes it clear that there was no further meeting scheduled because it was the only correspondence prior to your lawyers becoming involved that was shared with you after that meeting. You'll find it at page 130. Apologies. Page 130 is the aspect of Mr. Madlala's affidavit where he addresses this. And then we will go to the actual page where the email he sent you is recorded.
What page is the email?
The email you'll find at page 228. Let's go straight there if we may.
Yes.
Ms. Natterson, do you see in the second half of that email, that page, there's an email from Mr. Madlala to yourself, amongst others.
Yes,
What is the date of that email?
6th of May.
Do you see there that it reads, Dear Mr. Natterson, please find attached your draft statement for signature and the annexures thereof. I've also listed the information requested per our meeting today. Please relook at the statement and provide the necessary documentation as per below, preferable by Friday, 10 May 2019. Do you see that?
Yes.
Do you have any other knowledge of any correspondence or interactions that scheduled a meeting for the 10th of May?
Now, I've assumed that I must arrive on the 10th of May to hand over those documents. So I've assumed there was another meeting to happen to hand it over.
Had you driven to the Commission whenever you'd provided the Commission with documents previously?
Prior to the appointment of the attorneys, yes.
You had never sent them via email?
There were certain ones we sent via email that we had on hand immediately, but generally at a meeting I would hand over. Like, for example, there was, I think, my shareholder's certificate, etc., that I brought on the morning of the meeting and handed over.
So you understood this email to say there's going to be another meeting at which you're going to hand over those documents?
That's how I understood it.
Thank you. Then, if you go to page, was there ever another meeting?
No. At the point when the attorneys got involved, then the way this was handled changed.
If you then go back to page 64, at paragraph 9.2, Ms. Natterson, on that page, you take issue with the fact that you had not been informed of, amongst other things, your right to have your legal representative present at the meeting. And you complain that you were an unassisted layperson, whereas representatives of the Commission were legal practitioners or otherwise well-versed in legalities and rules of the Commission. Do you see that?
Yes.
Do you maintain that you had not, prior to the meeting on the 6th of May, been alerted to your right to legal representation?
No. I was informed. I think, Chair, maybe if I can give clarity to this. When I was first contacted by Mr. Madlala, I then appeared or arrived at the offices, and I worked through, I presented the evidence relating to my 204 and used that as the basis to present my evidence. Mr. Madlala and the rest of the representatives in the room also wanted to direct further questions over and above just the 204, which
Yes.
I cooperated with. The basis of my interaction was that there was already a Section 204 in place. So I understood my role as literally being state's witness in providing and cooperating with the Commission's objectives. It evolved from that meeting and the other meetings to eventually the 6th of May meeting, where Advocate Hofmeyer was involved, where at that point I realized that the Commission was actually going further and deeper than just the evidence that I had provided. And at that point I realized that I needed a legal representative, because then at that meeting it was indicated by Advocate Hofmeyer that she intended looking at my role relative to what happened as me being deficient or negligent or complicit in what happened with Van Wyk. So at that point I chose to bring legal representatives on. Prior to that, yes, I was informed of my rights, but I am advised later that by my legal counsel that the rules of explaining who accused me, I wasn't presented with that evidence at the start. It was merely that there was payments made to me, but the absolute content of Ms. Slatana's evidence was not given to me at the time. And it's through the intervention of my attorneys that we started to actually retrieve information that gave me a better background to actually what was being looked for.
Okay, thank you.
So, Mr. Natson, back at page 64, when you state under oath there, I was not informed of my rights, that is false.
That is not true.
Sorry, you also made reference to the meeting of the 6th of May, to which you've made reference I attended. Your affidavit indicates that I also attended the first meeting you had with the Commission on the 15th of March. Do you maintain that?
No, that's not true.
You will find at page 57 you indicated that I was at that first meeting. That is false.
Okay, concede.
If we then go to page 65, you'll find at paragraph 10 there, you say the following. A first draft of the statement mentioned at paragraph 9, that's the previous paragraph we were looking at, was duly completed by the representatives of the Commission, which draft statement was forwarded to me on or about 6 May 2019 by Madlala. A copy of the relevant correspondence by Madlala is attached here too. Mr. Natson, do you maintain that that first draft of your statement was sent to you only on the 6th of May?
I can't recall the date.
If I told you it was sent the preceding Friday, the 3rd of May, as set out in Mr. Madlala's affidavit, would you take issue with that?
No, it was sent out on the Friday because that's when Mr. Madlala called me to ask me to sign it.
Correct. So why is that not stated at paragraph 10?
Okay. No, it would have been the Friday before the 3rd.
That's the 3rd, correct.
That's an oversight.
And I also want to pick up your language at the beginning of that sentence, a first draft of the statement. Do you see that?
Yes?
Are you aware that it wasn't the first draft of the statement that was sent to you even on the 3rd of May while we make that correction?
I don't recall another draft.
You don't recall making track changes to an earlier draft earlier in the year?
It may have been.
So if I can show you the draft that you made track changes in, you'll accept that that is incorrect at
Yes,
paragraph
yes.
10.
Yes.
That statement, I'd like to get your version on today, Mr. Natterson, because earlier this morning when I took you to it, you indicated, remember it's the one at page 21, in fairness to you, I'd just like you to go back to it so you can see it. You said that you had signed it, you saw that you'd signed it, and you said that you confirmed that its contents are true and correct. Do you recall that?
Yes.
Now, in correspondence from your attorneys on the 10th of May, there is a statement that you reject this statement. Are you aware of that?
Yes.
Did you instruct them to include that in the letter?
I was advised to do so.
How can you both reject it and this morning confirm that its contents are true?
I think we need to refer to the inconsistencies. So, again, Chair, the evolution of this, and again, it's in the context of how the company is run. So, yes, I am the chair, the CEO, and a sole director, and a shareholder. But I am also very operational on the projects in the field. So, our modus operandi as a company is I have an accounts team. And so when this topic came about, a lot of the compilation of evidence and so on to be able to meet the further requirements of the Commission, I had to go back to the office to go and retrieve information, like, for example, invoices, etc., where my understanding initially that there might have been invoices. When I went back to the office to confirm with the accounting division, there were no invoices. So on that basis, there were corrections required. So yes, at a point in time, it was correct. But later on, when I go and get further evidence, we find that there's a different situation that existed.
So maybe you should tell me why you said you were rejecting it at a certain stage.
I think to the extent that it relates to invoices, initially in the interaction with Mr. Madlala from the investigative unit, I understood that there possibly would have been invoices. I then went back to the office, and then when I worked with the accounts team, we found there was a rational explanation as to why there weren't invoices. Because the understanding was the monies were dividend from Van Wyk, from a company he purported to own and control, to us, and therefore it is not revenue in our hands. So therefore an invoice should not exist for it.
Yeah.
Right? So on that basis, we had processed the transaction in a certain way. When I discovered that, I then sent an email across to the investigative unit to explain that.
Yeah.
So although the affidavit covered it in a certain way, my interactions with the Commission's investigation unit covered it in a certain way. When I went back and retrieved the information and cut back, yes, obviously a different situation existed, which I then informed them of.
Okay.
Mr. Nathan, the trouble I have with that is that this statement we're looking at page 21 makes no reference at all to invoices.
Now, I was using an example of the evolution.
The Chair's question was, in what respect do you reject the statement that appears at page 21? So I understood your answer, it was because it refers to invoices, which you'd subsequently discovered didn't exist, correct?
No, I was giving an example of the various, we have multiple versions of affidavits here.
So what do you reject in the statement that appears at page 21?
Okay, I don't have the exact specifics here now for that. Obviously, I was under advisement in the way the affidavit was put together, so we can revert on that.
Okay, maybe let's do this. It's correct your position at some stage was that you were rejecting this statement. Is that correct?
I think
Was that your position at a certain stage?
I think, yes, under advice, it was
Yes.
my position at the time.
Yes. And as you sit there, do you still reject it?
I think, Chair, the context, where there are inconsistencies, as we develop content, so where there are inconsistencies, the later version will then correct the previous deficiency. If we can see it
Yes.
from that perspective, then yes, I agree. There are accurate elements, and we
Yes.
will identify the elements that are not accurate as we go along.
So I guess that what you are saying is, as you sit there, you are saying there are many things in the statement that are correct, that you are happy with,
Correct.
but there are certain things that as you sit there now think they are not correct.
Correct.
Is that correct?
That's right.
Okay.
Ms. Nathan, do you accept that the role of this commission is to uncover the truth about what happened in relation to state capture, corruption and fraud in the public sector?
Yes, I agree.
Your legal representative raised an objection earlier as to the relevance of this line of questioning, and Chair, I'd like to deal with it pertinently now. Mr. Natson, the challenge that the Commission has experienced in engaging with you over this period is that there are numerous versions over time that you have supplied which continue to be inconsistent with later versions. Do you accept that characterization of your various statements and affidavits?
I think, again, in context, as I went back and identified further information, I would then revert with that content. And if it refuted previous versions, then yes, that's true.
So are we to understand that at any point in time that you depose to an affidavit, it's the facts that you regard as true then, but if there's subsequent facts that you uncover, you then recognize that those facts previously indicated were false and that you're now going to rely on the later version?
Yes.
Thank you.
Chair, sorry, could I just add to that,
Mm-hmm.
please?
Yes. Yes.
Chair, when one swears to an affidavit, when one deposes to an affidavit, the content, when you take the oath, you asked whether you have read and understood the affidavit and whether to the best of your knowledge and belief the contents are true and correct. My client has said now on 3 separate occasions that at the time when he deposed to those statements, with the knowledge he had at the time, that he believed the statement to be true and correct. If further knowledge and information came to his attention at a later stage, obviously that would necessitate a further statement. To the extent that the 2 statements may have discrepancies or inconsistencies, there's a logical explanation for it.
Yes, but Ms. Hofmeyer, you intervened when she had just obtained that concession from
But Chair,
the witness.
again, the inference that one draws, sitting and listening to the line of questioning, is that Ms. Hofmeyer is trying to paint the picture that my client has been dishonest, that he has not given statements which are true and correct. that he's misrepresented the truth. He's explained that that's not the case. He's given a logical explanation for why the statements have changed over time as information came to his attention, and that's not accepted.
Well, let's do it this way, Mr. Pinar. I suggest that you record or make notes of all your concerns as we go along. And at a certain stage, you can discuss that with Ms. Hofmeyer, or give her your concerns. She might be able to correct whatever misconception there may be. But if you feel strongly at a later stage about any particular point, you can raise it with me, and if need be, we'll find a way of sorting it out.
That's fine. I'm
but
raising it now. I want it on record now, because
yeah,
I do feel that it's prejudicial.
But at this stage, really, I don't see any problem at this stage. But let's go on. Maybe later on there would be, and then we can deal with it at that stage. He has indicated, that is the witness, that he would depose to an affidavit or make a statement on facts that he knew at the time. But later on, when other facts came out, which necessitated him changing, then he would do that. Ms. Hofmeyer has left it at that stage in terms of what he has said. She has not so far taken it further. What she makes of that is something that we might hear about later on. And then when she wants to make an issue of it, then we can deal with it at that stage.
I hear you, Chair, but I think, given the tone of the tone, the wording, and the line of questioning that's been taken, I think the intention is clear. The intention is to cast aspersions on the veracity of the evidence that's been given, and I don't think it's fair.
Well, put it this way, Mr. Pinar. In putting questions to the witness, she is required to try and assist me to get to the bottom of what happened, and she may be doing this in order to help me with that. And at this stage, I don't see any problem in the questions. It may or may not be that later on she will say, well, this is the point I want to make out of the answer you gave earlier. And then at that stage, we can deal with it.
And if that point isn't made?
If it's not made, it's up to you what you want to do with that. Because
then
if
the
it's
damage
not
is
made,
already done, Chair.
But no, I mean, you can ask me if I can grant you leave to re-examine Mr. Natterson, and I will look at that at that stage. So, but really, there's no problem at this stage, no problem whatsoever.
I think we just have to be practical about the inconsistencies, and I think, Chair, if I can ask for your guidance, insofar as the questioning is proceeding, if I can ask you to potentially intervene. When Mr. Natterson has explained the logical reasoning behind the change in the statements, on 3 separate occasions, I'm asking if you could please intervene and just put an end to the line of questioning there, because it just doesn't seem to be taking it any further.
You can rest assured that as I listen to the questions and the answers, I am alert. I am alive to whether there is any unfairness that I see. And with or without your intervention, where I think there is unfairness, I will intervene. But you must feel free, if there is a concern, to raise it. But the only thing I want to say to you is, maybe let's not have too many interruptions, because then we won't have progress. But when there is really something quite serious, then you
Chair, this to me is serious, and I'll tell you why. Because I understand the line of questioning, where it's going. Okay, I understand.
Yes.
My client may not, because he's not a legally trained individual.
Yeah.
I understand the protections afforded by 204, and I understand the requirements that have to be met in order for that protection to be in place.
Yes, but at this stage,
and I can understand where the line of questioning is going, and what the intention behind it is, and what Ms. Hofmeyer is trying to achieve. From that perspective, I believe it to be prejudicial. Mr. Natterson is being very cooperative. He's been cooperative with the Commission from the get-go. He has been honest in his dealings with the Commission. He has given them every bit of information that he's been requested to provide. He's done so under oath. I can tell you that he wouldn't perjure himself on these statements if it was not for the fact that at the time that he gave the statement, he believed the information that he was giving was true and correct.
Well, Mr. Pienaar, you may be overly concerned. To a very large extent, I think the witness has been able to handle questions that have been put to him. I haven't seen any big problem so far. Where there have been inconsistencies, he has conceded that, no, I made a mistake there, that's not true. Here I believe it's true, or there I believed at the time it was true. So you may be overly concerned.
Sure. Once again, I'll leave it there.
Yes.
But we need to see the relevance of this line of questioning.
No, at this stage, I think it's still fine, Mr. Pienaar, but I'm alive to your concerns, and
thank you.
If there is need for him to interfere, I will interfere. Okay, thank you. Ms. Hofmeyer, let's proceed.
Thank you, Chair. Mr. Natterson, I'd now like to move to aspects of your evidence which I take to be uncontentious. So if we could go to your Section 204 statement for that, and if we begin at page 3 of Exhibit DD10A. And I'd like to pick it up at paragraph 5, which you will find at page 6. I'd like to start at paragraph 5, as this is where I understand your Section 204 declaration deals with the actual movement of funds. Do you see that?
Correct.
And can you tell us what facts you set out at paragraph 5 there?
I refer to the amounts that were transferred into Neo Solutions, an amount of 5 million on the 11th of November 2015, and 4.9 million on the 12th of November 2015.
I'd like to then pick it up with the bank statements that you attach to that declaration. You'll find them at page 13, as I have it. Is that the bank statement that reflects those two receipts from Coroneka into Neo Solutions bank account?
Yes.
And just that reference there, what did that reference mean to you at the time under the transaction column?
I have no idea. That was what reflected on the bank statement.
And just for the purposes of the record, Chair, it reads Coroneka-KT1001 for both of those transactions on the 11th and the 12th of November. But can you confirm those were the transactions of funds that you understood were being paid to Neo Solutions on the instruction of Mr. Van Wyk?
That's right.
Thank you. If we then go over the page, and we pick
Sorry,
it...
Chair. Do we not need to contextualize the basis that Van Wyk transferred these funds to us?
She will ask you when she needs to cover that.
Okay.
At this stage, she just wanted you to confirm that those transactions related to your relationship with Mr. Van Wyk.
Okay.
So we're just tracking the flow of funds at the moment. That's why I'd like to pick it up at paragraph 7 on page 7.
Mm-hmm.
And I'm trying to do this in chronology. So your previous evidence was on the 11th and the 12th of November 2015. Two amounts come into Neo Solutions bank account in the amount of 5 million and 4.9 million, correct?
That's right.
Then as I read your declaration, the first amount goes out, as you describe it at paragraph 7. Can you please explain to us what happens there?
So on the 11th of December, an amount of 4 million was paid out via EFT to Batsamai Investment Holdings.
Thank you. And then we go down to paragraph 8, Because that refers to what happened on the 22nd of December. What happened on the 22nd of December?
A further amount of 3 million was paid out to that same account.
From the Neo Solutions account to the Batsama Investments account. Is that correct?
That's correct.
Then just to stick with the chronology, if we go back up to, sorry, it actually comes later, it comes twice in this affidavit, but if you go to page 8 at paragraph 11, if we track in the chronology, that's the next payment that I'm aware of. Is that correct?
That's right.
Tell us what happened as you record at paragraph 11.
So Van Wyk requested a portion of the funds in cash, or an amount of 300,000 was paid to him or given to him on the 4th of January.
Okay, let's
2016.
just follow those up with the relevant bank statements, if we may. So if you start at page 15, 1-5, can you tell us what that page shows?
On the 11th of, it's a bank statement from on our account at Neo Solutions. 11th of December, payment of 4 million. And then on the 22nd of December, a further payment of 3 million.
And you can confirm those were payments to Batsama Investments, is
That's
that
right.
right?
I
Thank
think
you.
we had sent through the proof of payments over and above the statement in the further request from the Commission's investigators.
Indeed. If you go back a page to page 14, what does page 14 show?
It shows an amount of 300,000 leaving the net bank account going across to our standard bank account.
And just explain that reference under the transaction.
It says Neo Solutions loan.
Why was it given that description?
I'm not sure why my accountant described it as that.
And then if we go back to page 7, we pick it up at paragraph 9. That, as I have it in the chronology, is the next payment. Can you tell us what that was?
That was on the 10th of March 2016, an amount of 1.4 million paid across to Batsama.
And then the last transaction, as I have it, is the next paragraph. Can you tell us what that was?
Paragraph 10, on the 29th of March 2016, an amount of 1.2 million paid over to Batsama.
Again, EFT from Neo Solutions bank account to Batsama bank account.
That's correct.
Mr. Nasson, there's a difference in March, as I have it, only insofar as those funds were paid from a different bank account. Is that correct?
From our standard bank account.
Okay. So just in summary then, and you'll correct me if this is inaccurate, in total 9.9 million was paid into Neo Solutions' Ned Bank account by Coroneka Projects and Trading. Is that correct?
That's right.
And that happened in November of 2015.
That's right.
Then between December of 2015 and March of 2016, 9.6 million was paid by EFT transactions to the bank account of Batsama Holdings Investment, correct?
That's right.
And 300,000 was paid in cash to Mr. Van Wyk
That's right.
on the 4th of January 2016, correct?
That's correct.
Thank you. And then I'd like to pick it up at page 8, Mr. Natterson. And at paragraph 14 there, can you indicate to the Commission what you state at paragraph 14?
I state that neither Neo Solutions nor myself has benefited financially in any way from this transaction.
And as you give your evidence today, do you stand by that assertion?
Yes.
Ms. Nasson, you requested at the outset of this line of questioning that you'd like to go to the explanation for these funds, and we must certainly do that. I'd like to pick that up from page 6 of your declaration. And if we can commence at paragraph 3, because that is where I have it, you begin to describe your relationship with Mr. Van Wyk. Can you explain to the Commission what the nature of that relationship was?
Yeah, I think it might be actually quite helpful if I use my affidavit of today, because I actually
Certainly.
cover it in there.
So let's go there.
So it'll be
On what page is that affidavit again?
Chair, it commences at 238.61.
Okay.
Chair, if I can take you to 238.62.
Yes.
And there's a section called background, and just after that it says relationship with Van Wyk and farming venture. Okay.
Yes, you
So-
may continue.
So just to provide the full picture, so I had met Brian van Wyk around 2014 through a former employee, in fact, and he started to engage with us. I think he gravitated to, the group also owns a magazine called Prestige, and he used to come to a lot of the Prestige events. I was aware at the time, or informed by him, that he was an employee of SA Express. But we'd never done work, we've never engaged in any sort of way with SA Express or Van Wyk or anything else before then. Since then, since that time, he started to spend a lot of time coming to even to our offices. At some point at one of the events, he had informed me that it was his intention to leave SA Express around June 2016. He sort of indicated a date, which to me meant he had a fixed term contract of some sort. And he had mentioned also that he had lots of private business interests before he joined SA Express. From my understanding that he was trained as a chartered accountant by BMW South Africa, and then did a little bit of tenure at VW as well. So from that understanding, we sort of gelled. The fact that he was a chartered accountant, the fact that he was business oriented, and from what I understood in the way he spoke, he didn't think his time at SA Express was going to be long term. He wasn't getting on with public sector at all. And for me, Van Wyk is quite eloquent, and he's quite good on business plans and so on, from what we saw with the way he was doing the farming venture stuff eventually. But even at the time, I could see the way he spoke about business and the things he would like to do. I actually almost saw him as a potential future business partner on various things. So because he was competent, and for me, there comes a point where also, like I said earlier, that I didn't want to stay as a consultant for the long term. And to me, he could be one of those candidates who could come in and actually relieve some of that from me. And really, he spoke in that way as well. Then in around October 2015 is when he approached me to say he had a private enterprise elsewhere, and he was receiving a dividend from that enterprise. He did say that obviously from his perspective that he wanted to not reveal the income from that to anyone. So he asked us to hold those funds for him and invest in businesses with us. Those discussions, I know I refer in my affidavit here to the farming venture per se, but there were other discussions about, he had a passion for classic cars, and in that there was plans to open up a panel beating business for classic cars together. Although that was a passion project, it wasn't a big business case. But there were those types of discussions that evolved along the way. Ultimately, he then said he was receiving a dividend of the 10 million, which my 204 refers to. This is the context of that 204, of the 10 million to come. The intention was, obviously, he was going to set up businesses or participate in businesses with us. I also assumed he would build his own business, because not everything was aligned with us. So that a portion of the funds would go. At the same, that was around, as I said, October. And he said, in fact, at that point, he said the funds would be imminently coming. It only, in fact, arrived in November when it came through. In that time, we were already starting onto this farming business, or the food distribution business, and he wanted a piece of that as well. So from what I understood from the initial investment required, we would be required to come up with an equity portion ourselves, and he said he had money to place in for his portion of that equity. Okay, so from that perspective, I took it on face value that the guy's a businessman. He's obviously leaving public sector employ, and would be then becoming quite operational as he left SA Express. He would be joining this business to actually run it. In fact, most of the interaction he had, and I'll explain later who was involved in the farming or the food distribution business case, he literally chaired that team in terms of putting the business plan together. But the arrival of those funds, at the time, yes, I agreed that I will assist him. I also understood him to be, like I am, a chartered accountant, operating by a certain set of rules, that his declarations of whatever he needed to declare from an interest perspective at SA Express that he had complied with, and he was a friend. So to me, it was getting to the point where there's a business associate that was going to come out of this process that I could trust, and that was thinking in the same way we were thinking around taking the business away from just purely selling time towards being a proper infrastructure business or a business that has annuity income. And that was the pretext of how these discussions evolved. I mean, at the end of the day, I took it on his word that he had done his homework and he's done his correct, that he's transferring these funds in good faith.
Sorry, did you say pretext?
Well, in terms of before these monies arrived, I'm trying to give you the context, the context of it.
Mr. Nathan, if we can go back to page 6, if we may, that is in your declaration.
Yes.
I'd like to just get clarity as to what was set out at paragraph 4 on that page, because some of what you've indicated in your answer to the chair is reflected here, some is not, and so I want your confirmation as to whether these facts set out here are accurate. So the first sentence reads, Van Beek approached me in November 2015 and asked if he can transfer 10 million rand into the bank account of Neo Solutions. I understand the only change there in the basis of what you said was that it might have preceded that in October. Is that right?
Yes, yes.
He then goes on and says, you record. He explained that it was necessary to do it this way as he was an official of the state, employed at SA Express, and was leaving. Do you see that?
Yes.
Is that what he said to you?
Well, I've now explained it in the context. This is how UDEAL had captured it in preparing the draft for me.
But you don't have a difficulty with it as it's stated there?
As it's stated here, obviously there was an intention from us to receive his 10 million dividend and to hold it, to put it into the businesses going forward.
But there's no factual inaccuracy in that statement?
No, to the extent it complies with our thinking, we had agreed to receive it.
Mr. Nasson, all that you reflect here is what he said. I'm just trying to understand from you. Do you today accept that he said that it was necessary to do it this way, transfer 10 million rand into the Neo Solutions bank account, as he was an official of the state, employed at SA Express and was leaving? Is that what he said?
That's what he said to me.
Thank you. It goes on. You record there, I asked for his confirmation that the funds were above board and that we would not be implicated in any wrongdoing, and he confirmed as such. Is that what you said to each other?
I firstly confirmed, in fact there were two layers. I confirmed that it had nothing to do with SA Express, and I also asked him, was it related to any state enterprise? And to both he had said no.
As I have it from the transcript of your first interview with the Commission, you also made reference to the fact that you asked him whether the money was clean. Yes. Do you remember that?
Yes.
In particular? And what was his answer?
He said, yes, it's from a private business and it has nothing to do with the state.
And why were you asking that type of question of Mr. Van Beek?
Well, I was aware he was a state official. So from that perspective, I had to make sure there was no conflict of interest with him obviously bringing these funds to us.
And then if we go back to page 6, you'll see the last sentence of paragraph 4. The only reason was that he didn't want his employers to be jealous, that he'd implemented a successful business and that he was in the process of parting ways with SA Express. Is that what he said?
That's what he said.
So he referred specifically to his employers being jealous. Do you recall that?
Yes, he did refer to them. Obviously, if they're aware that he's made 10 million elsewhere, that there would be an issue of jealousy of him.
Why jealousy? Did you probe that with him, Mr. Natson?
I didn't, but I understood in the context that obviously if he's now leaving and people are aware that he's making money elsewhere, then that might be construed that there would be jealousy around.
But if they were jealous, what could they do about it?
Nothing really, Chair. All I did was I took it on face value that he had he had applied his mind to the transaction to make sure, well, he confirmed to me unequivocally that this money had nothing to do with SA Express.
Yes, but you were, as I understand the position, and you must tell me if my understanding is incorrect, you wanted to make sure that you didn't receive money that was not clean.
Correct.
You didn't want to receive money that was illegally obtained. Is that right?
That's right.
So he says to you, I've got money that I've made from my private businesses, but I would like you to keep it in your business accounts for a certain period of time. I don't want to keep it in my business, in my accounts, because if SA Express becomes aware of it, they'll be jealous. My thinking is, the first question is, one, why would they be jealous? Two, and so what? What will they do? It's your money.
His statement was that public officials don't like other people making money.
Yeah, but would that be a reason for him not
it's
to
not
keep
at
the
all.
money?
I mean, I dealt with that on the basis, I understand where you're coming from, Chair. Is should I probe further? But the guy was my friend. He gave me undertakings that there was nothing untoward with these funds, right? And that he had complied with whatever was his requirements for conflicts of interest, etc. That was his undertakings.
But you were keen to make sure that you didn't receive money that was not clean. That's my concern.
That's right. But I
It
relied
tells-
on his undertaking. He was a CA as well.
He tells you a story that, to me, subject to what I will hear, doesn't really seem to make sense. They'll be jealous, and then they'll do what? If he got the money legitimately, they can't do anything about it. So why doesn't he want to keep the money in his own account?
Yeah,
I think that's the question you should have raised.
I think yes. As we said at the time, in the context of how he raised it with me, I understood it that he earned the money from a clean source or a reputable source, that it's no conflicts, and I took it on its face value at the time, that he had done that homework.
Ms. Natterson, in your interview with the Commission that was recorded, you also made reference to the fact that he had said he didn't want the money to hit his bank account. Do you recall saying that?
Yes,
Did he say that to you?
yes.
And the explanation that he gave, as I understood that recording, was that SA Express does lifestyle audits from time to time. Is that correct?
He had mentioned lifestyle audits.
Is that what he said in the conversation about these funds?
That's right.
Did you probe why they would be doing a lifestyle audit of Mr. Van Wyk?
I assume that lifestyle audits was a regular course of any senior position at a state entity.
That a state entity can go into the private bank accounts of their employees to audit their lifestyles.
From what I understood of SOEs, they do check on it.
Do they check because they wake up one morning and want to, or because usually there's some concern about wrongdoing?
I assumed it's either routine, depending, or if there's a genuine risk that emerges, that there would be a specific investigation.
Did you ask him about why they would be doing lifestyle audits of him?
No, I assumed it was a general statement. It wasn't a lifestyle audit on him that he referred to. I never understood it as a lifestyle audit on him. I assumed it was a routine thing, which was a condition of his employment, that all senior executives were subjected to.
Right, so he says, well, he may not have said, but you assumed it's a routine matter. The consequence of the lifestyle audit, if the funds were in his account, is that SA Express would have seen 10 million sitting in his account, correct?
Yeah, yes.
He says he doesn't want it to hit his account because of these lifestyle audits that occur. Is that correct?
Yes.
And just to reiterate what the chair was engaging with you earlier on, how could that possibly be a problem for Mr. Van Wyk if that 10 million rand had legitimately been obtained by him?
He didn't indicate that was a problem. He just said he'd prefer not to, because he
Yes.
was leaving.
But Mr. Natterson, you are a chartered accountant. You know issues about corruption that are happening in the country. here is somebody who is employed somewhere, who says to you he has got money that he has received legitimately from private businesses. But he says he doesn't want to keep it in his own account. He wants you to keep it for him in your business account. Why don't you smell that there must be something wrong with this?
He indicated it was from a business he had worked in or implemented well before he went to the state. That's the indication I had from him. So it wasn't even his current state earnings. It was a project he had in Northwest from a while ago.
But Mr. Matterson, whatever the circumstances, if the money that he wanted you to keep for him was legitimately obtained, why would that be a problem for him? Because if asked about it, he would give an explanation that he has confidence in will satisfy any reasonable person. Why was it a problem for him to keep it in his own account? I'm saying that's a question that you should have asked yourself. And I think that's what Ms. Hofmeyer is also
No, fair enough. I think,
leading
Chair,
to. And the question is, particularly because you had already thought about, hey, I don't want any dirty money.
correct.
So therefore, you are looking for a plausible explanation. Was this a plausible explanation?
He had said that he had preferred it. And obviously, because we were already underway with the discussion of business ventures together, in that context, at that point in time, I accepted his version. He had said preferred.
But I asked the question now, and we can talk about then. Did he give you a plausible explanation for asking you to keep the money for him?
The plausible explanation was to go into the business ventures. So we were working on the basis that the money was coming to us to invest in business. It wasn't to be returned to him. At that point in time, my understanding was that he was going to put the money with us and we were going to go into business transactions together. It was obviously the money he was placing would represent his equity in those deals.
But Mr. Natterson, if the purpose of him asking you to keep the money for him because you are going to go into business together, why would the issue of lifestyle audits come up?
As I said, he had mentioned it in passing. He said preferably he didn't want to take it directly to him. He would put it straight into the business.
But if he mentioned that, the issue of lifestyle audits in circumstances where your understanding was that he's asking you to put the money into your business account because that was money that was going to help in the business that you were going to be involved with him, your response would be, what lifestyle audits?
I did.
Why are you telling me about lifestyle audits? You are paying this money so that because we are going to go into business together. That would have been the response, isn't
But
it?
I did ask him that exactly those questions,
And
his response was, but he'd prefer it to come to us. He didn't want it to go to his.
did that make sense to you?
It made sense in that we were doing the business venture at the same time. So from that context, I understood it in that way.
Ms. Nassen, in your evidence, you referred on a few occasions to you and Mr. van Wyk being friends. Is that right?
Yeah, he became very friendly with us. I mean, I'd never been to his house though, so he would always come across to us. I only understood it that he lived in Blue Valley and that he would always just arrive at the office. Normally he would come in like 3:30 to the offices, and if there was a function or a braai, he would arrive there.
In that transcript of that interview with the Commission, you spoke about, I read it to be your concern that you were just trying to help a mate out. I think those were your words. And this thing had got a whole lot bigger. Do you remember saying that?
Yeah, I think it's in the transcript, yes.
Well, is that a fair, as you sit here today, is that a fair reflection of your state of mind at the time? You were trying to help a mate out.
Well, there was also an intention, obviously, to get these business units going. So if there was a person who was saying he can come in and be operational, so it was more than just helping a friend out. He had value to bring to the operations of what we were setting up.
And why not just transfer those funds to you rather than Neo Solutions?
I don't I don't transact much with me, so I don't understand why I would transfer the funds. In my mind, Neo Solutions was busy with a business case to implement a business, right? Once that business was up, those funds would have been transferred from there as the shareholding into the entity. So I would not do it personally. There's no basis for me to do it personally. I can't even relate to that.
So in October 2015, when you started to have these discussions with Mr. van Wyk, was that understanding of the venture as developed as you describe it at the moment?
No, at that stage it was incubating, but there was an intention for him to be 50-50 with me in it.
So
we later diluted him, but at that point in time it was us wanting to do it together.
So October 2015, he approaches you, he says he doesn't want this money to hit his bank account. He wants to put it in Neo Solutions. And your understanding at that time is it can sit in Neo Solutions because there's some venture we're embarking upon and it will constitute his equity contribution. Is that correct?
Correct.
Chair, I see we are at the lunch adjournment, if it's convenient.
Yes. We'll take the lunch adjournment and we'll resume at 2 o'clock. We adjourn.
All right.